Hey, 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 hey. It is your girl, Cassandra Lynn, and welcome to Legal Doc Talk. Oh, let me see. Okay, guys, so I've been monitoring her cases this morning. Not gonna be long because I gotta go pick up my child from college. And it's fair weekend in Texas. Yeah, I've been trying to multitask. I've been multitasking, working, and trying to stay up to date with Chrisean's cases. So this is over her civil case. I did a mini video. I guess you would call it a mini video. But hey, Michelle, what's up? What's up? What's up? Yeah, so this is just I did a mini video over her criminal case. Now I am going to speak on her civil case. As I stated earlier this week, she had two things that were going on. She had her criminal revocation docket hearing that was scheduled for today, but has since been rescheduled or continued to. Um, every time I get on this live, my dogs want to act up, and my kids home today. Jesus. Um, but she that hearing was continued to November 8th. Okay, so I did a video. So if you're not aware, just go watch it. It's 3 minutes, probably less than that without the intro. So what I wanted to discuss briefly is her civil case, and specifically with Wright, James Wright, and her. When we initially looked at her case earlier this week, it was just an answered filed. But since then, she has filed a case management statement, which is pretty much telling the court exactly where they are in the process. It does not require her attendance. It is just a civil case. I did have a question on the comments on the videos about asking about witnesses. Um, and I can't remember if it was under the criminal video that I did or the civil case. But in civil cases, it's not like criminal cases. So when there is a witness available, what we do is we either have them do a affidavit on their behalf, but there are times where both parties are being deposed and witnesses are able to be deposed as well by both counsels, plaintiff and defendant's counsels. And then the next time a witness can be questioned or deposed is during trial. For the Wright case, no trial has been set. As I stated prior, they are still in the discovery phase. There are things that both sides have to produce when you're dealing with discovery. So I did show you guys, a little bit about what is asked in discovery as far as like interrogatories and requests for production. And if they don't receive those documents or pictures or whatever it is that they're requesting, then they go through the subpoena. Well, go through the subpoena. They will subpoena those records or subpoena certain people to testify. Um, and I wouldn't even say testify. You can subpoena somebody just to come to a hearing. So it just all depends. But like I said, they are in the discovery phase. Shout out to Miss Tiana Gaines. Yes, I am having a great afternoon. I'm actually about to do this and then go pick up my college student who wants to come home for the weekend. I'm in Texas, so we have the Texas State Fair. So, and my I should say elementary and high school kid, they have a 4-day weekend. And they want to do all this stuff. So I'm gonna take a 4 days off and just have fun with my kids. Let's see. Michelle said, "Hi, Sandra. So proud that Chrisean and her lawyer is standing on business." Yes, they are standing on business, which is awesome. I did have an opportunity to look at Chrisean's civil lawyer, and she's awesome. Like, I got to see all the cases that she's currently handling her and her firm, and they are the business. Even with her criminal attorney is based out of Oklahoma City. If y'all don't know, Oklahoma City is far from Craig, or what is that, Vienna or whatever, part of Oklahoma, way up there in the northern part of Oklahoma. But anywho's, that criminal case is awesome. I surely will. I surely will. But for my reason for getting on here is, we got to talk about what has been filed. So, what do I want to show first? I guess I'm gonna share this. I'm gonna share the docket right quick. So as of right now, and I have been refreshing and refreshing and refreshing, so nothing has been updated. And I also have a system that I actually go into to get more up to date information and filings, but nothing has been filed. So either one, they haven't been heard yet, or two, nothing has been updated. But as of right now, it's still showing this. It doesn't show anything else. But as I stated prior, let's see. I believe, I don't know when I checked it. I have to go back and watch the video. But the last thing that was filed was Chrisean's answer. Then I come back today and I was like, oh, James filed a declaration. What is that? And then well, not yesterday, on the 9th, Chrisean's attorney filed the case management statement. Now, as far a declaration, everybody like, okay, what's a declaration? What's a declaration? Declaration is like an affidavit. However, with the affidavit, it has to be notarized, but it is your truth. Okay. You are defending why you are suing this person. Texas does it a little bit different than California, because the way that we do it is when we're going through the discovery phase, we ask certain questions that you have to provide for us. We ask and request certain documents that you have to provide for us. If you do not provide those documents, then we're going to go ahead and subpoena those documents from various sources. So in interrogatories, we may ask, what is your phone number? Who is your phone carrier? So that way we can obtain text messages, call logs, whatever the case may be on that part. We will subpoena Facebook, all your social media, iCloud, whatever we need that we feel that will be, um, what can I say, used as evidence in a case, we will request that. And it's all done in the discovery phase. And I'm trying to go back and forth. Tina said, I'm in Texas too. We might go to the fair tomorrow. My son is going to his granny's. You always do an amazing job with your information. Thank you so much. Thank you. And yeah, I live in Richardson. So, um, yeah, my kids, we're trying to debate whether I want to take them to the fair on Monday, but my middle child wants to take his friends. And I'm like, oh, Lord, but I want to spend time with my oldest child. I'm all over the place. Okay, so what we are looking at is, let's see, Michelle said, if James lies about anything, the whole case should be thrown out. Okay, now with civil cases, it's a little bit different. It's not something that can just be thrown out. Uh, what happens is he has a duty to, and y'all hear me say this term always, as the burden of proof is on the person who files the lawsuit. So in this case, James has to make sure that he proves up his allegations. Okay. Um, and the cool thing about me is that I have been on both sides of the fence when I am assisting attorneys in these type of cases, whether it's the plaintiff side or it's the defendant side. But at the end of the day, when it's coming to that discovery part, it's all the same. You answer questions, you produce documents, you give it to the other opposing counsel to go through and do whatever it is that they need to do, and then they go to depositions. So, to go back on the declaration, like I said, it's different than a affidavit, because with a declaration, you really don't have to get notarized, but I have to make sure I look at that and see if it's notarized. But it is your truth. and James has to, I haven't read it yet, so I don't know exactly what he has put, but if it's a declaration and he's proving the allegations, normally what we do in personal injury cases is we provide medical records and we provide billing records. You can submit all the bills you want, but the medical records have to justify those bills. Okay. For example, if so for instance, James, if James saying his tooth got knocked out, you can submit a bill showing dental work, but you also have to show me the medical records that say, okay, the what am I trying to say? The visit and the surgery or whatever was medically necessary and related to the incident that took place, whatever date that was. Okay, that is how that works. I'm gonna give you guys an example. Hold up, and I am going to go over a case that has already been done. Now, I ain't gonna show y'all my drives because I got a whole bunch of files on this. Mr. Larry Mr. Larry, Mr. Larry Wilkinson. What I want to show y'all. Okay, I don't have his medical records because that's with the other firm, but man, when I left them, I took all the documents that I drafted because I drafted these, okay? All right, so let me replace this. And I'm gonna give y'all a background on Mr. Wilkinson. All right, so this was a trucking case that I did. Okay, this is back in 2021. Um, Pretty much what happened is a truck merged into his lane. His car got stuck up under the truck and it kept going. He made a claim that he hit his head. So he had like some type of traumatic brain injury. And this is the plaintiff side, Mr. Larry Wilkins. That's who we that was our client. Um in the midst of that, now mind you guys, and so that's why depositions are so important as well, because a lot of times these clients don't be truthful with you, and we don't find out a lot of stuff until we get to depositions, which is a good thing and a bad thing. So we was not aware that he hit his teeth on the steering wheel. So I had to, and now we're in litigation. You have made this statement in your deposition. Mind you guys, you still have pre-litigation. So we do work prior to filing this in the courts. So I'm the case manager. I'm the paralegal on the case. So I have to go through everything. And I'm asking him, that's the first thing when I do my intake is, what were your injuries that you sustained in this incident? Never once did he mention that his tooth got knocked out. All right. So fast forward to the deposition, he states that, and then we're like, oh my gosh, now we got to get the medical records and bills from the dental's office so that way we can look and see if this is true. So we had to prove that we had to prove that this man's tooth got knocked out by the steering wheel during the incident. Okay, so fast forward to the whatchamacallit, thank God he went to the dentist's office like the day after the incident happened. And so it was included in your medical records. If it was not included in the medical records, then there's no way to tie you losing your tooth in that particular incident. So they will have to throw out that that bill. Okay, the opposing party can't pay for something that's not related to the incident. All right, so here in Texas, what we do, and I love Texas, I love Texas, I love Texas in this aspect, is that we have to, in order to prove your damages, we have to file what's called a notice of filing of medical records and billing affidavits. So when we request our records from medical providers, we have to get an affidavit that shows, okay, this is a true and correct copy of these medical records. They haven't been altered in any way. And then this is the true amount that was spent on services for this medical provider. And so here I have to go through all of his, like I go through medical records. When I do personal injury, I go from start to finish, from intake all the way to settlement. If it doesn't settle and we go to trial, I handle it all the way through trial. So I know every aspect of PI. So here is a list of all of the providers that he went to see. And I had to request medical records and billing records affidavits. So as you can see, we have to file this with the court. So here, and I'm just going to go to his dental records. Yeah, this is the dental records right here. So he's saying, I don't even know how much that is. So his insurance is a little blurry, but his insurance ended up paying for his medical, okay? But anywho's, I wanted to show you that because this is what you do in order to prove up your damages, all right? So for Mr. James, I don't know exactly. Well, before we get to that, let's look at the third. So no, this is the ninth. When did she file this? Oh, let me pull it up. I'm sorry, y'all. Uh, Let me get back to Chrisean's file. So I haven't even bothered to even read the declaration, so I don't know what James done say. How many pages? This 19. Lord Jesus. All right, I have personal knowledge and facts here. And let me see if he even, because I'll show y'all that's the. All right, so as y'all can see, this is only a declaration. So a declaration does not have to be notarized. All right. With an affidavit has to be notarized. And I just showed y'all that in whatchamacallit. Where is it at? Come on, slow. See, affidavit. Affidavit, it's notarized. Declarations are not notarized. So I just want to say, I just want to put that out there. I just want to put that out there. All right. So let's see. And I'm just gonna kind of skim through this. So he has personal knowledge of the facts herein. November 11th, he was in the dressing room. He suffered injuries as he was struck several times in the face by a defendant. That night, he'd been performing with Tamar. During the show, there was a popular segment called Twerking. Called Twerking. That was okay. Defendant Malone was not scheduled to perform. See, that's the thing. It's too much back and forth. Either she was to perform or she wasn't to perform. Which one is it? I gotta go back and look at his initial police report and see. Okay, so who was not scheduled to perform became upset because she did not get to perform on the night of the show. Defendant's name was called several times. However, she never came to the stage. She was irate about not being able to perform, wherein and I tried to console her. And if y'all know, I have always told you this. Whether Chrisean, everything is alleged, first of all, but you don't have permission to console anybody. Okay. That's why I always say you ask somebody if it's okay for them to touch you. You're like, is it okay? And then you proceed to do whatever it is that you do. So that's where you messed up at. During our conversation, I repeatedly tried to comfort her to no avail. She said that if I said one more word to her, she would hit me. I continued I continued to console her. And she punched me in my face several times, causing lacerations due to the rings that she was wearing on both hands. Once again, you continue to console her. If I see somebody mad, it's different. Like if I know that you're angry mad, okay, I'm backing up. It's a difference between somebody who is grieving and you're trying to console them versus somebody who is mad and you're trying to console them. that it just pisses you off more that somebody is trying to touch you and you're trying to get your point across. Not saying that she was right in any way what she did, it's all alleged, but at the same time, this is just common sense. I couldn't believe what happened. I was bleeding, disoriented, and embarrassed. My nose and lip were cut open, and my tooth was chipped. As a result of her actions, I endured a lot of physical, mental, emotional pain. Yes, yes, yes. 3 months. So it took 3 months from him to heal. So if that is if that is the case, I need to see 3 months of medical records from the day of the incident all the way till the end of 3 months. Okay. She literally turned my life upside down. When all I tried to do was help her, I went into hiding for safety reasons and I had to withdraw from social media. That is a lie. And I pray, well, you know what? This attorney, she's bomb anyway. I know she's going to subpoena some records because I'm pretty sure this man he ain't provided not near record. But on that side, if you're saying that you went into hiding and you had to withdraw from social media, guess what I'm going to do? I'm going to subpoena your social media. Okay. You can't delete. Y'all heard me say this too. Y'all cannot delete anything off of your Facebook, your Snapchat, your Instagram, your WhatsApp, whatever. You cannot delete. It goes somewhere. It goes somewhere. The first time I ever figured that out, I was in family court helping an attorney, and they pulled up this husband's Snapchat. Baby, that's how I was like, I love court. I love court. But anywho's, as a result, my personal business was impacted. I am a social media influencer with nearly 500,000 followers. Additionally, I had to cancel performances and catering jobs due to the threat and ridicule I was receiving at this time. I've already said it. They're gonna subpoena your records, my boy. If you have a personal business, then more than likely what's going to happen is we need to see your W-2s going all the way back to when I would say 5 to 10 years back, showing that you was making this amount of money. Like how much did you really lose? You got to prove that up. Oh, yep, to prove up his damages. This is going to be interesting. I couldn't even go to the grocery store or into public without hiding my identity. Bro, we seen you on social media. During my recovery, I had to take a leave of absence from work, losing thousands of dollars in wage. So were you employed? Because at the end of the day, I need to see tax returns. I need to see W-2s. I need to see pay stubs. I need to see something. The dental bills and therapy alone are overwhelming. Not only are those appointments expensive, but they take up my time every week. Okay, but we're not going to pay you for your time that it took up. We're going to pay you for the amount of your dental bills. And if your dental bills, I thought you said just one tooth. How much can your dental bills be for just one tooth? And your therapy, we got to see that your therapy was actually connected to this incident. Uh-huh. Today, I still think about this incident and how it has impacted my life. The fact that she has evaded this court and denied responsibility of her actions has made me even more upset and prolongs my healing. This is standard language that they normally use, but at the same time, um, I believe that the social media posts and your comments and text messages, whatever this attorney finds out, is really going to shape how much it impacted your life. You have flashbacks and panic attacks. You don't know if you'll ever be the same again. hmm I asked the court to consider the full impact this accident has had on my life and hold the defendant accountable. You know, one thing that a good attorney always told me in litigation, you never use the word accident, especially in personal injury. You never use the word accident. If it is a trucking or car wreck, I use collision. All right, because when you do accident, then it was what do you think about when we say accident? Oh, I'm sorry, it was an accident. I didn't mean to hit you. Okay? I didn't mean to hit you. Oh, okay. You say I'm sorry and you're done. So it was an accident, okay? But we don't use accident in litigation. We use either collision for or wreck for car wrecks, trucking wrecks, and for like slip and falls and all this other stuff, we say incident, but we never say accident. All right. All right. Let my puppies out because they about to get a whooping. Hold on. I don't know whoever convinced me to get two dogs. I believe that was my boyfriend, but hey, and he decided to go work in the oil field. So now I'm stuck with two puppies, two kids. Ciao. All right. So the total amount of requesting. All right. And mind you, so this is a declaration to prove up. So you need to be able to prove up the total amount that you're requesting. So an amount of damages, which would be your medical bills, 71,400. Pain and suffering, that is not a guarantee. Okay. $50,000. Service of process, $1,656. I know these process are hmm. How much now? That right there is a little iffy. I have to see receipts because normally a process server, it does not take that much unless you ended up moving for a motion to substitute service by citation by publication, where you have to post in a newspaper for a consecutive amount of weeks. So that's iffy. 15,000 for attorney's fees, administrative costs. Now, in Texas, we do PI cases on contingency, meaning that nothing is paid up front. We get paid at the end if we settle. Okay. Now, as far as attorney fees goes, that could include, the filing of the petition, if they had to make any type of court appearances, things of that nature. But 15,000, I hope the attorney, where's the attorney declaration? I didn't see that filed, but I want to see that. Administrative costs of 450. Now, administrative costs, that right there, that's the cost of filing this litigation. But attorney fees, I don't know about that. So the exhibits to prove up these judgments. Let's see what he said. Let's see what he said. And I'm looking at the comments. Yeah, you're right. Nobody is responsible for what their fans do. He was on social media the very next day. I bet. I think I seen that too. But you went into hiding. He should have never touched her without her permission. And that's the thing. That is the thing. Uh Now, on the plaintiff side, normally in this type of situation, we do recommend that if you are experiencing any type of mental or what you want to anxiety or something like that, we do recommend that you go see a therapist, right? Now, even though, wait, hold up. Okay, so Miss Ebony Jefferson, Conversations of the Heart, the pastor. So you didn't go to a licensed professional? And there is a difference between a therapist and an actual, psychiatrist. One is licensed, the other one is not. One can prescribe drugs, the other one cannot. So you have therapy. Okay. So that came out to 1500. We're going to see about this part because Stephanie, I'm not in Oklahoma. I am in Texas. However, I handle personal injury for Texas, California, Florida, and Georgia. Yeah. So I contract myself with several attorneys in those states. So I'm aware of when it comes to personal injury, that is my forte. That's my forte right there. Then criminal, then family law. When you don't know a person's history or background, especially a female who has been SA, don't ever attempt to touch them. Trauma bond is real. Yeah, that is true. But at the end of the day, you still have to ask permission. That's like when you're pregnant and people just come up and rub your pregnant belly. Don't nobody like that. You ask permission. You ask permission. Let's see. So that one right there, the attorney, if I was her, I would definitely ask one why you didn't go to a licensed therapist. But yeah, definitely have to see those records one to even see if he actually went to those sessions based off of what happened. Oh yeah, no, cost is different in each state. However, like I said, with service, it does not cost that much because I have done service in California. It does not cost that much. Oh, I know. Good thing I'm not a judge. You is so right. And I'm not biased. I'm explaining the situation on both ends. Okay? All right. So that is that. You have to be able to prove up. Let me see. All right. So this is the law off. Okay, this is the law office. So and they explain their rate. All right. That's cool. Boy, they charged from, but they was not playing. Hold on. Hold on. Let me read that. So this is the law office. There you said that the attorney's fees was 15,000. Yet, oh, this is the process server. Okay. Okay. Now this makes sense. So and that's yep. Normally their rate, a process server in a civil case, their rate is gonna be anywhere from $75 to $85. But they use a private one. So the 14th, the 8th, the 10th, the 16th. Well, I need to become a process server, add something in my belt. All right, so that makes sense. But here, this is normally what we do after six. Let me see, that's 6 attempts. Is this a typo? So you tried, hold on. When was this case filed? Hold on. Hold on. Because why it has a 2023 date? I thought this case wasn't filed until I'm pulling up I'm pulling up the complaint. This case was filed 2/6/24. So this first one needs to, I don't know if it's a typo, but that needs to come off. I be a Yeah, I just looked at it. It says February 6th, 2024. So they need to go ahead and he needs to look at this one because that's not correct. Take that off. But that makes sense. They're going to travel for each attempt. They're going to travel for each attempt. All right. And then the mileage. I'm a mobile notary, so I get it. I do the same thing. All right. So going down to Exhibit C, this is an invoice for Friendsgiving catering. Catering of, okay. And so here, this is the invoice. So you have invoices. And here's the thing with this invoice here. And once again, I am no way trying to be biased. I'm working this as if I was the defense, okay? Assisting ChriseanRock, okay? You have these invoices that shows that you missed out on these opportunities. Um, but normally what happens is we have to request W-2s and other statements to any, because if you're saying this is your business, But we have to see that you make a steady flow of income from this if you're claiming that you missed out on these opportunities. One thing about this is it has no date stamp. It doesn't have anything. So anybody could have gone in and I'm not saying altered, but even I can go into my what you call that, my accounting system, and if I wanted to do an invoice, I can set it for a certain date in the past. So I could say, hey, this invoice was created September 4th, 2022. Okay, so we have to actually look at the validity of these statements. So they're not just going to base it off of these statements. My dogs, Lord, base it off of the statements. They're going to also request W-2s if they haven't done already, or any 1099s, whatever the case may be. Prepared for. All right. And these are just now, here's the thing. The other things that we just looked up, that's one thing. But the records, we need medical records from the actual therapist. You need actual records from this is the dental. Now everybody say, well, why you need medical records? And I haven't done this case yet, but um Soldier Boy's baby mama, remember when she sued Blueface? I was able to get her declaration. I have gone through it. She actually produced medical records showing her going to therapy and bills. That is how you prove up your damages. Oh yeah, that's why I love doing what I do, because I be up in folks' business. Yes, you can always send a verification to vendors. Let's see. Hold on. Hold on. This is his whole mouth. Tooth 4, 5, 6, 7, 8, 9. How many teeth we got in our head, y'all? Now, you complained that one tooth was messed up, if I'm not mistaken. You said tooth or two? So we need to see actual medical records to show that each of these teeth were medically necessary to replace. If it has nothing to do with the incident, then that cannot be included in your damages. You have to prove that 49,400 was from this incident. I don't see it. And even in the initial set, I have to go back and look at the incident report, because if I'm not mistaken, I don't see anything where he said that he went to the EMS. Because here's how it goes. If you were involved in an incident where you were assaulted, or whether you are in a wreck, or whether you are in a slip and fall, you report it to somebody. I don't remember in that incident report, because I think they said EMS came out, but he rejected their services or something like that. He declined their services. I don't know. But this right here, this is not required. Even the dude that I just showed y'all, the case that I handled back in 2021, his mouth hit the steering wheel. Oh, it's like, boy, I thought it was my child calling me. His mouth hit the steering wheel. Only one tooth, and his medical insurance paid for that. And it was not as near as this. They didn't have to replace all his teeth. So that's one thing. So definitely have to see if this was medically necessary in regards to the incident. Veneers. Why did he automatically go to a specialist and not a general? That this right here, this right here. Now on the defense side, because even on the plaintiff side, Defense counsel always asks that. That's like a person in a car wreck. Instead of them going to the emergency room, they go straight to a chiropractor. And the question that is always asked, well, why did you go straight to a chiropractor? Yes. So that's a very good question. And I'm pretty sure, I hope that is in those interrogatories. He failed miserably for a chipped tooth. He lied and they lied. Yes. Veneers are placed differently. One can cause others to shift. Keep that in mind. Didn't know that. Chipped veneers can't be fixed. The total has to be replaced. Mm. Mm. Interesting. All right. Who is? I know I'm supposed to be doing work, so I got people who is calling me. To see if they receive the modification. Who this loan signings? I gotta call this person back. I need a vacation already. All right, so it says veneers, peers confirm. It says the goal of this plan is to tackle the most critical oral health issues. The table below presents all the procedures that should be completed to fulfill the treatment. Oh, that's all. That's all. So no medical records, no nothing. I'm sitting here scrolling, and that's all. Hold on, let me tell my kids to bring these puppies in this house. Okay, no, that's fine. Okay. Yeah, so that's it. No medical records, just bills. And this is not being biased in any way. This is how it works. You cannot just submit bills. You have to submit medical records because your medical records will have some type of notation from the doctor saying that this treatment was medically necessary in lieu of the incident. I repeat, the medical records will have notes from the doctor saying the treatment received was medically necessary because of the incident. Okay? No, no. So for there's visit notes. There you can request a whole, and I've done it, and I don't have access to the records because I do not work for that firm. But it does show visit notes from the doctor. See, a lot of people don't realize you guys can go ahead and request records, and I'm saying dental records, and you're only going to get so much. As a firm, we go through a whole different process. When we do attorney requests for medical records, dental records, therapy records, it is much more detailed. You guys won't see what we see. Okay, so that's what I want everybody to understand. It's totally different. So yes, we could get his medical records and his dental records, but the doctor specifically, the dentist has to specifically say we had to replace these because it was medically necessary due to the incident. That's how that works. Yeah, that's what I'm saying. Exactly. The medical records will also will also show him seeing them before he went there. That's what I'm saying. Medical records will show everything. But the medical records that law firms request, we get total I don't want to say we get totally different records, but we get more detailed records from the time you check in, who you spoke to, they're like whether it was a RN, a physician assistant, or whoever the case may be, we get more detailed records than what you guys will actually get from just the portal. All right. It's 206. All right. So that was his declaration. So his declaration is not notarized, but it is his truth. But it is his truth for, as far as him proving up his damages. All right. Now, that was filed on the 3rd. Fast forward to the 9th, Chrisean's attorney, I said Chrisean's attorney, filed this. Let's see. Party defended Chrisean. The type of case, it is a complaint for personal injury, assault, battery, infliction of emotional distress, requesting a jury trial. No trial date has been set. They still are in the discovery phase. If they do want a trial, oh, wait, hold up. Attorney is responding. Wait, attorney for this responding defendant can presently be available on or after April 3rd, 2025 to allow for this. Oh, I just said it, to allow for discovery and previously scheduled cases. Bam, right there. Estimated length of trial, 4 days, which is typical. Da, 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 da. What else we got going on here? All right, the parties are willing to participate. Yep, mediation, because how it goes, discovery, depositions. So that's like all the questioning and obtaining evidence. After that, they go to mediation. They try to settle. If they don't settle, then that's when they go to court. That's how that works. Settlement conference, not yet, because mediation hasn't been settled. Da, 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 da. Coverage issues will significantly affect the resolution of this case. All right. In personal injury, all right. Normally, what we do is when we get a case, we will send a letter of representation to the party's insurer. So whether it's a premises liability, whether it's a car wreck, whether it is, just a regular business, everybody should have sufficient coverage. So what they're saying is, in the event that this case does settle, insurance is going to be a problem, because here's the thing. If you don't have insurance, how are you going to pay? A lot of people think that it's like, okay, yeah, and yes, if there's a judgment, then eventually that they would have to pay out their pocket. And that has happened in several of the cases that I have. We went after assets, okay? House, boat, business, whatever the case, you need to come up with this money and pay this judgment. But normally, 90% of the time, we go through insurance. So if we get a case like a simple car wreck case, but the at-fault party does not have insurance, then there's nothing to collect the settlement from, and we decline it. It's hard to try to collect a settlement from somebody who does not have insurance, because there's where you're going to get the money from. And it is hard trying to recover a judgment. That's why a lot of PI firms, if they find out that the at-fault party doesn't have insurance, then it's like, what are we doing? You're just wasting money. But in Chrisean's case, everybody sees that she has money. So of course they'd be like, okay, well, she got assets. So let's go after that. If we get a judgment, then she'll pay out of pocket. All right. But what they're saying here is that currently insurance is being investigated. If there is insurance coverage, then the settlement can come out of that. All right. However, coverage will be affected by the allegations of intentional act by the responding party. Possible motions to compel. I like that. And normally, when we file motions to compel, that's either because you haven't produced anything that we're so in discovery. If they're compelling discovery, that means that, for instance, Chrisean may have requested, and I say Chrisean, her attorney, may have requested for certain medical records. They failed to produce those. So before we do a subpoena, we're gonna file a motion with the court that says, okay, can you compel this person or this party to produce these records? If it doesn't happen that way, then we're gonna go ahead and move on with a subpoena. All right. Discovery. So they have the following discovery will be completed by the date specified. So it's always a time period. So written discovery, like I told you guys, interrogatories, admissions, requests for production, subpoenas to social media, to the phone company, to other parties that were there, depositions of both Chrisean, depositions of anybody who was present at the show. So possibly Tame R. What's that other dude name? Leroy, Latroy, LaCoy, what, whatever his name is, he'll be deposed. James obviously will be deposed. Anybody that was there that can be, a witness to either party, they will depose them. Expert depositions. I love expert depositions because a lot of people don't realize how much work is put in when it comes to reviewing medical records and determining if this treatment was medically necessary for the other party to have. So in this case, you have to hire an expert. So that's why it's important to get the dental records or the medical records from the therapist or the medical provider, whether it's a chiropractor or the ER or even the dental, right? So you're going to bring in an expert that can say, yes, this treatment was medically necessary due to this incident. But they haven't got to that point yet because they're still trying to gather all of the evidence. Okay. So I'm pretty sure they'll update this. And I see the comments going. I don't think people get BBLs. I don't know what y'all got going on. Yeah, she doesn't have an insurance, and I sure hope that she uh gets insurance for her business. Like you need every type of insurance because anything can happen and people will come after you. Oh, let me see. Michelle said, "Can the video of his goddaughter saying that he was fine from his birthday be a part of the?" Yeah, that's what I'm saying. When we request, and that was on Instagram. I don't remember exactly what social media outlet it was, but when you subpoena any and all, social media relating to that incident, I'm sure that's going to be included in that. So she would go to trial for civil, but didn't go to trial for criminal. They didn't request a trial. This is just for her criminal. That was just simply a revocation. Or her probation was revoked. So it's not like you're going to trial. Okay. You don't have to go to trial for that. And first of all, she waived her rights for a jury trial in the beginning. Oh, wait. Cassandra question. Is this a preponderance of evidence and all they have to show Chrisean pursuant to violence of assault? Okay. And here's the thing. This is everybody thinks it's not like criminal law, okay? What it is an incident happened, an injury happened, and he is trying to get payment to cover his medical bills and for pain and suffering. Okay? So the evidence that is collected is not evidence to say, "Oh, Chrisean, you did this, so you're going to go to jail." No, that's not what this is. It's evidence. So Chrisean is collecting evidence to show he was definitely fine. So on the defense side, if I was, working for, on Chrisean's side with the firm, I would be gathering evidence to say, no, you're not injured because of this. You have a video stating that you wasn't injured. Okay. But you can't just base it off of a video. You have to have tangible evidence. So that's why medical records in an injury case, I repeat, in an injury case, you have to have medical records that states within those records that the treatment that you received is the cause of an incident. Otherwise, they don't have to pay for dilly squat. Okay? They don't have, you could go to the doctor, like who was y'all saying, a BBL and all this other stuff. It wasn't medically necessary for you to get a BBL. So I can, so if your bill was $10,000 and it cost $7,000 because you got a BBL, but the doctor checked you out because you had, a broken tooth or whatever the case may be that was related to the incident, and that cost $2,000, I'm only considering the $2,000. I'm not considering the rest of that bill. I hope that makes sense. Oh Lord, I don't know what y'all talking about in here. Y'all is crazy. All right, so that's discovery. Let's see. Now it says the following discovery issues, including issues regarding discovery of electronically stored information. Yes. So, number two, what has to happen in order for, now they're giving him a chance to provide his medical record, all of his medical records and bills, right? But if he doesn't, then that's when Chrisean's attorney has to step in and do so by subpoena. However, we can't just call the doctor and say, hey, I need this. You have to have a HIPAA form. So normally through the discovery, when you're doing the interrogatories and requests for production, and the admissions, we include forms, the HIPAA form, the form that we can obtain your taxes, the form that we can obtain your employment records, the form that we can obtain your social security records. Now, on the plaintiff side, do I have the client complete them? No. All the plaintiff firms and attorneys that I have worked for, they always say, do not complete those. Okay, so on the plaintiff side, he probably ain't gonna complete those. What's up, Dylan? Yeah, I am. My child rushed me to go get his brother. He missed his brother so much. um so it says defendant will be requesting employment records. All right. Because remember, y'all, if he owns his business and he has been at work, out of work, you have to show records that you were employed, show records that you made this amount, and it doesn't have to be a consistent amount. That's not the word I want to use, but you have to show, okay, I've been employed for this amount of times with this particular employer. Even if you own your own business, your 1099s, and supposedly you're supposed to be filing taxes when you have your business. So that's what they need it for. Counseling records. All right. He showed the bill, but that bill can be for anything. You could have went to your therapist and talk about how the sky is blue. That has nothing to do with this incident. All right. Medical records, aka the dentist. You just showed a bill. We need to see if it was medically necessary for you to get your whole mouth fixed. It is unknown at this time if the plaintiff will assist in providing the information and required releases in order to obtain this information in a timely manner. So, what they're saying is they have possibly already requested this, but he's not being, how can I say the word? He's not working with them. All right. He's not providing this information. So when they don't provide this information, you file a motion to compel to have the court say, okay, you got to provide this information. That's how that works. And yeah, they don't have a trial date, but they do. So this right here, 75 days, and that's within 75 days of the ninth. So a lot of people think that you can request records and you get it back. No, when attorneys do requests, it doesn't go straight to that medical provider or that vendor, because they actually have a third party either handling their medical records or their billing records. It takes anywhere from 30 to 45 days to actually get the requested records back. Now, I don't even know if they do records by affidavit. That would be a good part. I know that in Texas, we have a statute that it's like a 18.001 statute for affidavits. I know for California records, I have requested records, but no affidavit was needed. They need to adopt that law. But anywho's, they have 75 days, and they don't think that James is going to be willing to provide the necessary information in order to wrap this case up. So if there is any delay, it would be a delay on his part. She said, "Is there any leniency on James for Chrisean's failure to respond this lawsuit timely? It took her 6 months and no show at a prior." All right. So to answer your question, you can file an answer at any time during the litigation. But what? How can I? Okay. When the suit is filed, you serve the party, right? When you serve them, they have so many days to file an answer. For me, I be on the clock. I have everything calendar. So for instance, 20 days in Texas. So on that 21st day, if I don't see that you filed the answer, I'm a file for a default judgment. I believe, let me see, the James, when did he do an entry for default judgment? I mean, you could do it anytime prior to um, you know, the person filing a an answer. I'm looking on here and I think James I know I seen it. Okay, so I don't remember exactly when she was served, excuse me, but I do know that on the 9th of September, he put in a request or an entry for a default judgment. Now, did he do everything that he was supposed to do? I don't know. And the reason I say that is because normally with a default judgment, oh, you know what? I'm slow. I'm just not reading this if I read the whole title. So he put in his request for a default judgment. Then the declaration that we just read that showed all his therapy, all his bills and stuff, that was in support. So it was a declaration in support of the default judgment. All right. But since she filed her answer, the court is going to say, okay, and she hired an attorney. They're going to give her the opportunity to state her case. And when I say state her case, meaning that she's going to fight. She has to now prove that those medical bills weren't medically necessary. All right. So that is how they do it on the defense end. Back at May. All right. So yeah. Yeah, there was an issue with proof of service, but they squared that away. And so that's how he was able. If there was still an issue with the proof of service, he would not have been able to file an entry for default judgment. Because if there was an issue with service, that will dismiss the whole case. Okay, so going back to the PDF, where's it at? Where's it at? Case management. So yeah, that's the discovery. So they have 75 days in order to get all of the discovery, but they feel like he's not going to comply, especially with providing the releases in order to get the medical records themselves. And so more than likely she's going to file a motion to compel to have him provide that information. Economic meet and confer. Defendant intends to meet and confer prior to the court appearance on October 11th, but that is only 2 days away. It is unknown if this will take place. And that was today. I don't see that there was an update on the docket, but I will keep an eye on that. And that was sent to them. Service list, blase, blase, blase. Yeah, that's it. Close all these tabs. I need to go pick up my child too. So I'll show this last screen, and this is just what I was looking at to see. So as I stated, oh man, oh man. Let's see. LA courts. Please tell me I still got it. Copied and paste. Yeah, anybody can pfft, that was the case that I was working on. Cassandra. Hold that. I'm gonna check one more time. I gotta get the case number. And I'll get to your questions, but let me get the case number right quick and see if anything, because I want to see what the status or the minutes for this particular case. What was the outcome? But what time is it? It's 2, so that means it's 12. It's 12 there. Yeah, they haven't filed the minutes yet. So they haven't filed the minutes yet, but once the minutes come, then I'll definitely stop sharing. I will definitely provide probably like a little post or something. Let's see. Stephanie said, last question, if Chrisean can't pay her attorney and she withdraws, what happens, or does the attorney have to stay on the case? That's a very good question. I'm not sure if you were present earlier, but for personal injury cases such as this, is not you paying, the firm gets paid out of the settlement. Okay, what we call it is a contingency. So we don't get paid, we only get paid if there's a settlement. I hope that makes sense. So if well, you know what? I'm thinking of the plaintiff side. So for the plaintiff side, we only get paid if there is a settlement. I have to think on the defendant side. So on the defendant side, that's a little bit different. Um if she can't pay this, but how can I even say this? It's not like a criminal case. Um so it doesn't really have the same stipulations that it would, like, oh, if you can't pay me, then definitely I'm going to withdraw out your case. It's whatever type of agreement that Chrisean and the firm work with. I don't know what that agreement is. She didn't countersue, so I know that she's not expecting a settlement of any sorts. Um, but the attorney is not, an attorney can withdraw from a case at any time, but I totally just realized that she's on the defense side, so it's more than likely that she is paying her versus being on the plaintiff side. um but I don't know. Now in the event that the attorney just magically, withdraws from her case, will that hurt Chrisean? I don't know. um I'm not, I don't know. You can, in these type of cases, you can represent yourself, but it's not something that you should do, especially if you're the one who's being sued. I'm actually helping somebody right now, and he doesn't have an attorney. So I can't give him any legal advice, but I just want to tell him, bro, you need to go talk to an attorney. I could draft the documents. I could say yes or no, whether those, documents I'm able to draft and file for you. But as far as your process of going, like trying to defend yourself in a personal injury case, you really need an attorney, in my opinion. But if her attorney just happens to withdraw from this case, I don't know. I honestly, we would just have to see how it goes. I mean, right now, it's a timeline for which things have to happen. As you can see, discovery has a deadline, depositions has a deadline. If she gets to mediation, now, if she doesn't have an attorney, but she gets to mediation and they could work out a deal, and Chrisean say, hey, okay, let's say the plaintiff say, okay, we don't want however much, I don't even remember the total he asking for, but we can't pay, let's say it's 140,000. We can't, we're not demanding 140,000, but can you do 100K? And Chrisean be like, yeah, I could pay that. Boom, it's settled. But if they don't come to any agreement after that, they have to go to trial. And trial is 50-50 because either the plaintiff going to lose or the plaintiff is going to win. But for the defendant, how are you going to defend yourself? Chrisean doesn't have enough litigation experience, if any, to go represent herself. So I think, to answer your question, up to mediation, if she doesn't have an attorney, she'll survive. And this is after they have finished the discovery process. But if it has to go beyond that, no, she has to have an attorney. Stephanie says she's fighting against it, so more than likely she has already paid the lawyer dues. Correct. Does Chrisean have to be in court, or can her handle it? All right. So for civil cases, parties do not have to be in court. The only time they will appear in court is during trial. And 9 times out of 10, cases like these don't make it to trial. In a previous live, I told you guys the different, like I was talking about Tony Busby, about there's a difference between a trial lawyer and a litigation lawyer. And me and my the criminal lawyer was actually having a conversation last week about this. And I was like, I never really thought about that. A good litigation lawyer is somebody which in this case, Chrisean's lawyer, she's a good litigation attorney. I've never seen her in court. I have to do more research, but she's a good litigation attorney, which means that she can probably get this case, resolved during mediation. It is different when you step in the courtroom. Okay, so in court, you have to now turn off your litigation and go into trial mode. But to answer your question, I done went all over. Does Chrisean have to be in court? She does not have to be to court. The only time she has to go to court is when it is set for trial. So any of these settings that you guys see, case status, pretrial, any of those things, she does not have to be in court. Civil cases are totally different than criminal cases. James, who might be on, yes, he is on a contingency fee. So if he gets a good settlement, then the firm will get paid out of that settlement, and the medical providers will get paid out of that. And here's the thing with that. I'm going to tell y'all a little tricky trick. So when we obtain a settlement, let's say it's $100,000, right? And your medical bills is about a good $90,000. All right. You still have to think about attorney fees, case expenses, paying back medical providers that you've seen for the incident, paying back any subrogation liens in case that you got Medicaid, Medicare, or you used your private health insurance. What I do is I go back, and I need to be doing that because I need to go pick up my child so I can get on these cases. I negotiate those bills. So if a chiropractor has a $30,000 bill, I'll look and be like, okay, you trying to outdo yourself, kid. I'm not gonna pay you $30,000, but take this $10,000 and call it a day. So we actually end up negotiating your medical bills, your subrogation liens, to ensure that you get more money in your pocket. And that's the plaintiff side of things. As far as defendant goes, yes, they having to pay for defense. But during mediation, that is the time where they negotiate as far as let's come to an agreement. So I'm not going to pay you $140,000, but I'll pay you $30,000, for everything. And it's up to them whether or not they accept that. But if they can't come to any agreement, then you have to take your chances in court. I have seen where, and I spoke on this earlier this week, we've had a case where an attorney, like I said, he's more of a litigation attorney, not a trial attorney. He went to court and he lost. So they previously offered, this amount. And the client said, no, let's take it to trial. And I always try to explain to clients on the plaintiff side, look, it's a 50-50 chance because the jury you may get, they may see something like, oh, you was responsible, so we're not going to give you anything. So I don't know. This is going to be a very, very interesting case. Her lawyer is a civil boy criminal unless appearance is requested. Oh, her lawyer. This is civil. Okay. I'm not too much sure how to do that. If this go through Zeus in trouble, everyone coming after Zeus, this is a straight money grab. Zeus has not been sued for this. It's just Chrisean. It's just Chrisean. Now, if you have not seen my video, now as far as the Rama case and the hairdresser case, Zeus was sued, if I'm not mistaken, but I think James Wright only did Chrisean. I have to go back and look. Defendant has to retain. Yep. Mm-hmm. Yep. I had to think about that. I was on the plaintiff's side for a minute. Most likely she paid for them to pick up this case. She's not the defendant. The attorney can also ask to withdraw, but it won't be. No. And here's the thing, if a defense attorney does, well, no, I'm thinking about the plaintiff side again. Y'all, I need a break. That's why I need a vacation, y'all. I had a PIP, a PIP case, and an attorney dropped because of conflict of interest out of nowhere. Oh, wow. That's interesting. Okay, so it's about, yeah, he got to prove all that up. He doesn't have enough, in my personal opinion, on the plaintiff side, he doesn't have nothing that proves to me his care was 138,000. And not saying his care, yes, the total amount, but is that whole 138,000 related to the incident? That's what you have to prove. Yeah, she's not going anywhere. I don't think she's going anywhere. Even attorney is going to settle because to go to trial. Wait, even attorney is going to settle cause to go to trial. Hey, to go to trial, and they said 4 days. Trial is expensive, and the crazy thing is, as the plaintiff, if we go to trial and we don't get nothing, just think about all the money the attorneys has wasted. That's why when I say we, the whole firm, the paralegals, the attorneys, the everybody, we try to make sure we negotiate before we even get to trial, because that is crazy. She's good, and yes, she is. I've seen her case docket. Her firm is handling a lot of cases. I know you gotta go, but the sad part for Krishana, unless her money is long, she's gonna be dealing with 3 lawsuits. Yeah, she is, but I surely hope. And here's the thing, even though she's dealing with 3 lawsuits, I don't think that it's going to be nothing compared to what happens if they have to settle or if they go to court and it ends up being a judgment. So she better stick with her so she could try to get, if she does. And I've said this before earlier this week. I truly believe that James is going to walk away with something. It may not be that 138,000, but he's going to walk away with a settlement. I said what I said. I said this civil case, her appearance is only needed when requested. Yeah, but with civil cases, it's not requested. There's never going to be a time where the judge is going to be like, I'm requesting the party's appearance. Never, ever, 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 ever. The only day that they're going to walk into the courtroom is on those trial dates. Oh Lord. We can't be calling people rock haters. Hey, my purpose of my channel is just to read the court docs, go over court docs. I ain't taking sides. I'm just bringing y'all the point of view from me working as both sides, of the fence, the plaintiff and the defense. Defense, yeah, defense. Because there are a couple of cases, and I'm not gonna lie, for the defense side, it has been really challenging because it's different from the plaintiff side. It's like here we have to try to prove that, the plaintiff, how could I don't even want to say the plaintiff caused their own injuries, but it's something along those grounds. You know what I'm saying? She has different attorneys for each case. Yeah. Okay. No, she does not have different attorneys for each case. For her civil cases, in LA, she has the same attorney, Miss Monica. Okay. She answered two of the three cases. Now, monitoring the hairdressers or whoever that girl is case because I did not see an answer filed. But two of the three civil cases that Chrisean has in LA is handled by Monica. Her criminal case out of Oklahoma is handled by Mr. Martin out of Oklahoma City. He's one of the best criminal defense attorneys in Oklahoma. All right. So she only has two attorneys, one for criminal, one for civil. That's it. No. And here's the thing with that, and a lot of people get this misconstrued. One, she can't use one attorney for all. Now, I'm not sure if you're talking about just, her civil cases, but her civil cases, she does have one attorney. But if you're just talking about overall to handle her Oklahoma and her civil, that can't be done. Okay? Each attorney specializes in different areas of law. But first and foremost, a California attorney would have to, one, practice criminal law, but two, have a license in Oklahoma to practice to handle her criminal case, in which they have to do a pro hoc vice, just like the attorney from Florida did a pro hoc vice application to handle her case under a licensed Oklahoma attorney. So that's not going to work. Not all attorneys handle. I have several attorneys. I have one attorney that just does solely personal injury. I have another attorney who does personal injury and criminal law. I have another attorney that does estate planning and family law. Okay? I can't ask my family law and attorney to represent me or a client for a criminal case because that's not what he went, well, I can't say went to school for, but that's not his specialty. Okay? So don't ever think that a lawyer can cover all aspects of law. You have different areas of law. You have business litigation, you have commercial, you have family law, estate planning, commercial. um just Google it and you'll see. Just Google it and you'll see. Zeus is going to get paid 200K just for a one-time special appearance on Baddies, so I think she will at least can pay something. Oh, well, that'd be good. Gotta get money. Gotta get money somewhere. Mr. Martin and his daughters are good. I gotta go see them. I was thinking about going to Oklahoma, but I have not stepped foot in Oklahoma since my aunt passed, and it's really different. But I need to take a trip. No, Stephanie just keeps saying certain things. Why is she worried about rock funds and how long they are? Like, I know this is a public, but at some point she has a right to privacy. Yeah, I know. I know. All right. Yeah. So just civil, she has one attorney. That's it. Just one, Miss Monica. That's it. She has three. Chrisean has three civil cases, two in which Miss Monica is handling. As far as the hairdresser case, I don't know, but I'm looking at this to ensure, not to ensure, but to see if there's any updates, and if so, then I'll definitely update you guys on that. They don't even all practice in the same fields of law. Yes, three cases for civil. Correct. She has three civil cases: Rama, James Wright, and the hairdresser. Only for one tooth, whatever his police report stated, he wants her to pay for the other ones too. Yeah, but see, that is why we got to get those dental records, because that dentist. And here's the thing with that. So we get the dental records, we review it, and the dentist said that it was necessary for James to have this treatment, and so blase, blase, blase. Okay. So the medical records state, and I'm saying hypothetically, so if the dental records stated that he had to have this, operation or whatever treatment, that's that. This is where the experts come in. So remember where I showed y'all the timelines for written discovery, subpoenas, deposition, and experts depositions? This is where the defense will hire a expert in the dental field to review the records, and they will depose him and say, "Do you believe that the treatment received was medically necessary for the incident, from the incident?" That's where the experts come in at. Thank you, Gemini. Yes, my aunt, she passed. Man, it's been a rough year. She passed in November, and then my cousin ended up passing in May. No, actually in March, because we was in California. Um, yeah, so Oklahoma is just like, I don't know. I had to take a break from Oklahoma. Thank you. Thank you, though. Thank you very much. Gemini, the same reason you're worried about all the other aspects because it's expensive, and she did take care of legal when she was making millions. That's why. What if James Dentist is shady? Well, that's the whole purpose of hiring an expert in that field. So even though, like I said, if it's stated in the medical records that his, like, if his dentist says yes, this treatment was necessary, the defense will hire an expert in the dental field to review the records, and based off of his expertise will tell us whether or not the treatment James received was medically necessary. That's how that works. And y'all are awesome in this comments, we all adults. We all adults. That's good. My mom, dad too. Oh Lord. Blessings to you and prayers to you. Definitely. And that's how it is with my cousin. So my other cousin who still lives in Oklahoma, his father, well, my aunt and his dad is no longer on this earth. And I can't imagine. I really can't. Because I just have my mom, but we don't really have that good relationship. I don't know who my father is, so I can't really say anything on that. But prayers to you, because losing parents, that's a whole different ball game. Whew. Channel C say exactly. Expert testimony will Clint. Yes, it will. They'll clock it. They'll clock it. All right. So Denisha said, yep, he hasn't provided all the information and he never left in the ambulance. That is correct. Because the incident report, that's why I need to go back and look to see exactly what the incident report said. Because I believe, because normally when you call the police out, well, from what I thought, the ambulance would come, especially if you're reporting some type of injury. And I believe he declined their services. All right. And I think that is because, yep, I think that's what it was. I think that's what it was. And what's interesting to me is he only provided a therapist bill and a dentist bill. He didn't provide an ER bill or urgent care bill, any type of bill to shows that the laceration that he sustained, none of that. Where is all of those records? And so that is what this attorney, Chrisean's attorney, is trying to get. Y'all is crazy. Thank you, Michelle. Thank you. All right, guys. So I've been on here for an hour, 28 minutes. I need to get my son from college and come back and do some work because I spent my time with you guys. Got to settle these cases. Um, the police took too long to come. Well, even though um I always suggest that if there is some type of incident, wait for the police to come so that way you can have an incident report. If you are injured, go get checked out by the EMS. I mean, you can decline to go, you can decline that trip to the hospital. Um, especially if you're able to get to the hospital on your own, but for some strange reason you can't, you better take that trip to the hospital in the ambulance. Okay. Um, but you always want to make sure it's documented because if you don't make it a report, it's always he said, she said. And in the PI world, I always utilize the police report, the EMS report, the ER, and then whatever your treatment was with medical providers, depending on what type of injuries you have. Let's see. Gemini says Stephanie does not matter what one does on social media. They are entitled to some privacy. At least the law feels that way. My thing is, you worried about her funds when I hope your house is in order. Oh Lord Jesus. And I bet it's not. Y'all is going in. I'ma pray for y'all. I wondered that as well. Like, why wouldn't James' attorney would not provide that information from the hospital? There's two things, and I'm talking from the plaintiff's perspective. Not all PI firms out there are good. I'm just gonna y'all please do y'all research on that. My process is when I do an intake and the attorneys give me the green light to say whether or not we're gonna accept your case or not. So the first thing I always ask, I always ask about the facts of the case, but then when I get to the injuries, did you go to the hospital? If so, can you provide me with a copy of your discharge records? That's the first thing I always said. Now, the reason why James' attorney did not provide that information because the information could not be obtained because he didn't go to the hospital. If I'm trying to win a case, I'm going to give you, I, and I kid you guys not, if you went to the hospital, they're going to give you discharge paperwork. They're going to give you some type of estimate of what your bill is going to be. And if you pay through health insurance, you can easily obtain an EOB from your insurance, your health insurance company to submit. If not, if you stuck with that bill, then they're going to send you a bill in the mail. So when James sought out to get this attorney, all of that information I would have took and given to the attorney. That's why me as a paralegal, I know these injury cases, and that's the first thing I ask for. Now, if you say I have not gone and sought treatment, I'm asking you why you haven't gone. Oh, well, I just felt like, it didn't. And I get it. Like in these personal injury cases, as far as car wrecks and trekking wrecks, sometimes that adrenaline is going and you don't feel no pain until a couple of days after. I get it. But if you're coming to me 2 months and you talk about I was involved in a incident where I was injured 2 months ago, how can we fight for you I can't go to an insurance company and be like, hey, we're representing a client who was in a wreck 2 years ago, but they didn't go get checked out, but you're trying to do a bodily injury claim. How is that going to work out? So he didn't have any medical records other than the therapist and the dental to give, and I'm pretty sure that's all he got. You're welcome. You are welcome, Michelle. And let's be honest, you worried very much. I'm not worried at all. I support Cassandra, Chrisean, but baby, I'm not worried about you. Oh no, thank you, Cassandra. Good to have you back. I'll reach out later. Go get your child. Thank you, Steph. I love all y'all. Y'all awesome. I'm a corporate accountant. Okay. Okay. I do not put my information on social media holding stacks of money. Okay, that this part. Now I agree. I agree. I agree. I agree. I agree. I agree with this statement. And the only reason, and that's why I teach my kids. That's exact one, you can open up so many doors when you're flashing. Be humble. That's number one. But number two, it portrays what type of person you are. Now, and when I say it portrays, if I'm looking at your social media and the first thing I see you holding is a stack of money, my what am I trying to say? The first thing that comes to mind about you is that, oh my gosh, this ratchet person here. What? And that's what it is. You have to be careful what you put on social media because it comes back to bite you in your butt. That's why I said when we start subpoenaing these records, it shows everything. So that's why my kids are very mindful. I monitor, even my 18-year-old, I monitor what he put on his social media, even though he doesn't really even post. As an employer, why y'all think when y'all go out and get these jobs They ask you, some of these applications do ask you if you have social media. Do y'all not think that these employers go and look at your social media? I know I did. When I was working for one company and I was a supervisor, I had the opportunity to actually interview people. And yes, I did look at their social media, but I did allow them an opportunity to interview. But and that wasn't the only factor. But when you're, how can I say this? They act just like what's on their profile. If that makes sense. They act just like what's on their profile. No, you're not going to be a good fit here. So be mindful. And that is, I mean, we put a lot of information on social media. That's why some of you, if you try to befriend me on Instagram, I decline because my Instagram is private. Like what I share is with those that I talk to on a daily basis, or family, friends, or whoever the case may be. So I'm mindful, but on my, other accounts that are private, it's either fishing or my paralegal business, or even TikTok. My TikTok is public. And so I just do dances and all that other stuff. But that's, you do have to be careful about what you see. Because your business is out there. Like if you don't want your business out there, don't put it out there. Ah, y'all get it? Thanks for explaining because I handle family law, so I'm learning a little something. Oh, family law. Yes. Yeah, girl, these family law cases, I got one I'm handling with this Houston attorney, and baby, that's why I got to get off of here because I got to do an inventory and appraisement sheet, and I don't feel like doing it. Cassandra, when you have some time, can I message you about something? Yes, you can. You can. If you are on Instagram, it's at Miss Know It All. Just send me a friend request and I'll accept that. I'll say what my child. Hey, teach with the gemstones. The IR baby, the IRS child. I'm stay away from girl. You a corporate accountant for the IRS, baby. Y'all better have y'all. Y'all talk about the house in order. Y'all better have y'all financials in order. Then you said just like he tried with Patty, but he will still be given something for the chip tooth. Uh, the chip tooth was in the police report, and there are too many different stories from his side. Yeah, and that's what they're gonna look. We're gonna look at the police reports, the investigative reports, medical records, all of that good stuff. And if they demand a certain amount, we're gonna counter that and say, hey, we're not gonna pay you $140,000, but we can settle at $70,000 due to these reasons, and list those reasons, like your story is inconsistent, blah 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 blah. She called it a snitch. Oh no, you call it a snitch. Okay, stuff what she says, like I said, just to the point about the stacks. That is the only reason I brought it up. Her money and my background. She plays like she got stacks, but oh, I see what you're saying. I see. Yeah, a lot of people be fronting. A lot of people be fronting. I be doing these criminal cases. I go on their profile. They be calling us, talk about, can we do a payment plan? But bro, I just see you flashing all this money on your Instagram. Make that make sense. Pay me. Pay me. Pay the attorney so the attorney can pay me. Okay? Oh, okay. Not for the IRS. All right. What does your channel prepare for you? I'm curious what you do. Oh Lord Jesus. Y'all is killing me in these comments. I feel you. Family law is something else. I'm a paralegal and that's oh my gosh. From one paralegal to another. Hey Chanel. Baby, baby. I think, and it's funny because my criminal law attorney, the criminal law PI attorney, he wants me full time, and I'm like, I have to have a balance because I'm also a teacher, but I'm not. I put off teaching till next year, but I have to have a balance. So when I get tired of dealing with the family law stuff, then I'll hop over to PI or criminal law. And that's how that's why I like doing what I do. I love being a paralegal. Like I keep every week I'll be like, I'm gonna go to law school, and then I'll be like, nah, I like being a paralegal. My channel is not gambling. Oh Lord. Oh Lord, what y'all talk about in here? I have a gambling channel. Oh girl, you got a gambling channel. Girl, what you mean? Girl. What's up, Curly? Can Chrisean sue Tamar for a hostile work environment? That is a very good question. I really thought that Chrisean was going to countersue. Um, but I don't know. The issue with that is because the way Tamar portrayed it was that she invited Chrisean there just to invite her. I don't know, as she didn't invite her to perform. Now, if she invited her to perform, then that is another thing. That's another thing. That's a good question. That's something that I think Chrisean should actually ask the attorney. I own a real business. Look me up. I'm registered. Girl, we all registered up in here. Shout out to the business owners, the small business owners out there, to the paralegals. All right. So my youngest child, he keep calling my name. So y'all, thank y'all for tuning in. I hope that this was very informative for you guys. Just to kind of wrap everything up, the in the James Wright case, Chrisean filed an answer, as well as the Rama case. But more specifically to the James Wright case, he filed a declaration and attached all of these bills with no medical records. So it's very hard to say that they were medically necessary in lieu of what happened between him and Chrisean. Um, I am going to keep I'm going to monitor the case to see if they have updated the case minutes, because I want to know exactly what happened in that case management conference hearing. But at the same time, I forgot to tell you guys this, that Chrisean's attorney did update the docket with a case management statement that pretty much let the court know exactly where they are in the litigation process. James is not, providing information that is requested. They are setting deadlines for these cases, and Chrisean's attorney may move to file motion to compel the plaintiff to provide that information so that way they can move forth with the case. That will cause a delay. If you are trying to get a settlement and he's trying to prove up his damages, you can't just submit bills without the medical records. So if he's not going to submit the medical records and he's not going to fill out the forms, the HIPAA authorization and like the all these authorizations, and provide that to the defense attorney so she can order the records, then he's just going to cause a delay. Now, here's the thing. The judge will set a date. Now I know in Texas they set what's called a DWOP, a dismissal for want of prosecution, meaning if they don't see any movement on the docket, they will have a hearing. And if the parties or the attorneys go before the judge and they say, hey, we are at a standstill because this party won't produce any documents, then they can make the decisions there. But if nothing is being done by either side, they could dismiss it. Now that's in Texas. In California, they actually give folks a chance because, like I said, once that default judgment was entered, that would have been a wrap. Okay. But that is where we're at right now. So Chrisean's attorney for her civil cases, the 2 out of 3, is working diligently, especially on the James Wright case. He needs to produce documents. They're gotta force him to produce these documents because he's not gonna produce them on his own. Once they get all that done, they could get depositions out of the way and then move on. But yeah, so that's it. That is it. That is it. That is it. I'm gonna go these last few things. Can she LaTroy Davis for his despicable? I mean, let me tell y'all something. Anybody can sue anybody for anything. If you look at me wrong, I can sue you for looking at me wrong. But it's always going to be up to the person that is suing the other person to prove that to prove up their damages, if that makes sense. So you can, if she wanted to sue him for his despicable behavior and she's claiming that she suffered emotionally and she's claiming for damages, she got to prove that up. Okay, so it's not just easy. It's, you can sue, but you have to prove why you are suing. If I sold my time legally, what I got to do? Oh Lord Jesus, y'all still going at it. Y'all got me cracking up. I need Chrisean to do so cease and desist. That I hope so. I sure hope so. But you know, she has a good attorney, so I'm pretty sure her attorney will give her some good legal advice. Gemini, please don't spam the chat. Oh, okay. Yeah. So I got mods in there. So y'all be nice. Very informative. Take care, girl. Gemini, how? Okay, I'm gonna just go over y'all stuff. Okay, so this is the last one. Exactly. Where are the medical records, James? I wait for real. All right, y'all. I'm gonna get out of here. I gotta drive all the way to Arlington, which is like 45 minutes. Get my child. Gotta pack up his gaming computer, come home, and finish working. But it has been real, y'all. Thank y'all for tuning in. Y'all are awesome. Thank y'all to my members. Thank you to my mods. I'm gonna try to go live once a week. But it's really good to be able to chat with you guys and you know, talk about different conversations. But definitely let me know what else you guys want to talk about. I know I'll be posting all kinds of stuff on my channel just because I'm interested, so nobody else may be interested. Just like with Garth Brooks, you know, I don't have a large Garth Brooks fan base over here or hater base, but it's something that I was interested in. So I just like to read cases and, you know, talk about them. I'll be up, you know, recording them. Obviously, I'm talking to myself, but that's why I like to premiere them so that way I have an opportunity to chat with you guys in the chat. But yeah, so thanks again for coming. Don't forget to comment below, like, share, and subscribe my video. Until then, be blessed. And I'm out. Bye.